Hello and welcome to the Number 5 Planning Podcast. My name is Daniel Henderson. I'm a barrister at Number 5 Chambers and I'm joined today by Anna Stein, the newest member of the Planning and Environment Group at Number 5. Anna, good afternoon.
Good afternoon, Daniel.
Today we are going to be doing a sweep of topics to do with enforcement, various updates about what's new. We're going to look at some of the changes affected by LURA, including on various topics, time limits, heritage issues, and a few other bits and pieces that Anna's going to talk to us about. We're also going to have a look at an important Court of Appeal judgment from earlier this year on the scope of the so-called Murfitt principle, a case called Caldwell, which is of real significance. And then we'll round off by trying to distill that into some more useful practical tips when dealing with enforcement matters. So, LURA, 25th of April, was an important day in the world of planning. Now we've had a few months of those changes bedding in. Let's start by talking through some of the more important ones. First of all, some important changes in time limits. They're the big headline from an enforcement perspective. So first of all, what's going on with them and when do those changes actually come into effect?
The changes to time limits that LURA has introduced came into effect on the 25th of April 2024. The first change that's worth discussing is that found in section 115 of LURA, which has modified section 171B of the 1990 Town and Country Planning Act. Previously, that section provided that local authorities couldn't take enforcement action in respect of breaches of planning control following a period of 4 years for operational development or change of use of a single building house. However, other breaches, such as breach of condition, could be enforced against for up to 10 years. However, now that the section 115 of LURA has come into force, the period for enforcing against all breaches has been extended to 10 years. So now that this 10-year period exists across the board, the important thing to note is that the starting point for the running of this 10-year period does vary depending on the type of breach that concerns you. In section 115.1, which modifies section 171B1 of the 1990 Act, where there's been a breach of planning control of operational development, the clock starts to run on the date on which operations were substantially completed. And as previously, that remains a matter of fact and degree. So the substance of the law hasn't changed, simply the consequence in terms of the time period for enforcement is what has changed. Section 1152 of LURA modifies section 171B2 of the 1990 Act, which essentially says that where there's been a breach of planning control consisting of a change of use of any building to use as a single dwelling house, no enforcement action may be taken after the end of 10 years, beginning with the date of the breach. Now, it's important to add at this juncture that these changes or these provisions only apply in England. In Wales, the pre-existing changes in enforcement times remain unmodified by LURA. There are transitional provisions for the enactment of these changes. Essentially, the amendments made by section 115 of LURA do not apply where operations were substantially completed or the breach occurred on the day before the section came into force. So the operative point here is that if the breach or completion occurred before the 24th of April, the original 4-year time limit applies. For everything on that date or subsequent, it's now a 10-year period for enforcement.
So you're right, and very important to keep an eye on those transitional provisions. The old rules will be important for some time yet. Sticking with LURA, local authorities obviously have a wide range of choices available to them seeking to enforce. There have also been some important changes that we need to discuss in terms of stop notices and enforcement warning notices. Do you want to just take us through those?
Certainly. So section 116 of LURA deals with temporary stop notices. That's amending section 171E of the TCPA. Essentially, what that does is extends the possible duration of a temporary stop notice from 28 to 56 days. And again, the transitional provisions apply, so it only relates to temporary stop notices issued and not withdrawn on or after the 25th of April 2004. Other provisions that relate to temporary stop notices remain unchanged. And as with the enforcement time periods, the caveat that this only applies in England should also be noted. With regard to enforcement warning notices, modifications were introduced by section 117 of LURA, which formalises the process for LPAs to invite retrospective planning applications, which was done under section 172ZA of the 1990 Act, rapidly running out of numbers and letters for these provisions. Essentially, this section provides local authorities in England with the power to issue an enforcement warning notice where it appears there's been a breach of planning control, and there's a reasonable prospect that if an application for planning permission in respect of the development were made, planning permission would be granted. So this is essentially an attempt to provide a more formal basis for the somewhat informal process to date around retrospective planning applications. What's important for LPAs to recognise is that this section does go on to state the formalities which are required for the notice to be valid and the requirements for valid service. And usefully in the PPG, there is a model warning notice, which I would direct people to rather than having a stab at drafting their own. It should also be noted that issuance of an enforcement warning notice doesn't affect any other power that's exercisable in the breach of planning control. So, for example, if a retrospective planning application was not received within a specified time, a local authority may decide to take further enforcement action. The other interesting point is that there is no right of appeal to the Secretary of State against the serving of an enforcement warning notice. So it can become a useful tool in a local authority's arsenal.
It can indeed. While we're on appeals, if we do go with an enforcement notice, if that notice is then challenged by way of appeal, there are also a number of changes affected by LERA that we need to be aware of in that regard.
Absolutely. So Section 118 of LERA modifies Sections 174 brackets 2 brackets A and brackets 2 brackets B of the 1990 Act. And essentially what that does is remove the option of appeal under ground A. As I'm sure everyone listening, avid fans of planning law and enforcement will know, a ground A appeal is that in respect of a breach of planning control, which may be constituted by the matter stated in the notice, planning permission ought to be granted, or as the case may be, the condition or limitation concerned ought to be discharged. So what LURA has done in Section 118 is to remove this possibility. Essentially, to kind of put this in a more user-friendly scenario, if planning permission for what is alleged an enforcement notice has been refused by a local authority, and that refusal was appealed and the appeal was dismissed, and the appellant was then to go ahead and make the operational development or the change of use without planning permission, previously they were able to then run an appeal on ground A if the local authority chose to enforce. They now cannot run that appeal. So essentially it removes the third bite of the cherry. So just as an example, before the amendment, an appellant could apply for permission, appeal a refused permission, do the work anyway, receive an enforcement notice, have a final attempt at obtaining planning permission through ground A. That final attempt now isn't possible. So as with the other provisions that we've already discussed, this change does not apply to appeals against enforcement notices which were made and not withdrawn before 25th of April. So the vast majority of appeals which are currently ongoing can still be made validly on ground A. However, if you're receiving any appeals at this point that are trying to argue ground A, that's worth looking at.
Finally then, on LERA, Section 120 of LERA dealing with penalties for non-compliance. A couple of quick points on that, I think.
Simply to flag that Section 120 does increase the range of penalties for non-compliance for planning enforcement, and they apply to offences committed after the 25th of April 2024. And the changes apply to Section 187A of the Act, which relates to enforcement of conditions, and also Section 216 of the Act, which is non-compliance with Section 215 notice, the power to require proper maintenance of land.
Brilliant. Thank you very much indeed. Turning away from LERA then, and towards the important Court of Appeal decision earlier this year in Caldwell, and we'll put the citation for that in some explanatory notes. That deals with the Murfitt principle.
It
one
does.
of the many principles in planning law known only by the name of an obscure case from the 1970s. In this case, I think it was the 1980s, but anyway. Let's start by just thinking about what the Murfitt principle is. What actually are we talking about when we talk about the Murfitt principle?
The Murfitt principle allows for the removal of items which facilitate change of use, even if those items themselves are now immune from enforcement or are not development, as long as they are part and parcel of an unauthorised change of use. Putting that into more human sounding English, in practice, has to date provided an opportunity for local authorities to enforce against operational development, which would normally only have a 4-year time frame for enforcement. The Murfitt principle allows them to enforce within a 10-year time frame where there is material change of use which has occurred. Now, this principle has been nuanced through case law, but Caldwell has provided a very useful reframing of the Murfitt principle, and essentially is an opportunity for the Court of Appeal to set out the principles on which Murfitt is founded and on which we will all be relying going forward.
Yes, very much so. Well, let's take Caldwell then. First of all, tell us a little bit about what Caldwell concerns, timber yards and such like.
Indeed. So Mr. Caldwell owns a site in the Greenbelt. This site has been subject to a series of attempts to gain planning permission for a dwelling. All these applications have been refused by the local authority, who are Buckinghamshire County Council. Notwithstanding, a dwelling house was constructed in 2013 and subsequently completed in April 2014. The local authority did not enforce within the 4-year time frame for the operational development, but enforced 7 years later with an enforcement notice that alleged material change of use without planning permission and operational development to facilitate the unauthorised material change of use, which was the construction of a building occupied as a dwelling. Mr. Caldwell appealed the enforcement notice and an inquiry was held, and the inspector ordered the cessation of the residential use and the demolition of the bungalow, applying the Murfitt principle. Mr. Caldwell appealed the inspector's decision to the High Court, where Mrs. Justice Leven allowed the appeal and quashed the inspector's decision. The case was then further appealed to the Court of Appeal, with 2 issues to be determined. Firstly, whether the inspector erred in law in relation to the scope of the power to require the removal of operational development, pursuant to the power in section 173 (4) A of the 1990 Act. And the second was whether the inspector's application of the Murfitt principle was, in this case, irrational.
Indeed, and we had a unanimous judgment from the Senior President's Tribunal dealing with both of those points, although I think primarily the first. What did the Court of Appeal say, and what are the implications for that?
So the court upheld the judgment of Mrs. Justice Leven. It found that the inspector's application of the Murfitt principle was applied in error. And it set out 5 principles which arose in the course of its consideration. The first principle is that the limits of Murfitt should not be overstated. It operates within the bounds of a statutory scheme, which sets different time limits for enforcement against operational development and material changes of use. And I add a brief caveat here to say that it will not have application after 10 years, but at the time that this has become relevant, the 2 different enforcement periods have been running. So there are implications for these LURA updates that we mentioned at the top of the podcast. The second principle that the Court of Appeal set out is grounded in section 173 (4) A of the 1990 Act, which gives power to require the restoration of the land to its condition before the breach took place. However, the principle doesn't extend to works that are fundamental to or causative of the change of use itself. It can only apply to those works which are ancillary or secondary. The third principle is that the limitation of ancillary to is described differently throughout case law, and one will see references to integral to, associated with. But regardless of the use of words, they are synonymous, essentially. And the Senior President of the Tribunal agreed with Mrs. Justice Leven's description of the kind of works to which the Murfitt principle has been correctly applied as secondary, ancillary, or associated with the change of use. And he also approved facilitative only. For those who are interested in further analysis, paragraph 35 of Mrs. Justice Leven's judgment was cited specifically in the Court of Appeal's judgment, and that's really, I think, the definitive text for how we deal with these synonyms. The fourth principle is that Murfitt doesn't support the removal of a building or other operational development, which is a separate development in its own right, or works which are fundamental to or causative of the change of use. So, in other words, where an operational development has itself brought about a change of use, the Murfitt principle is not engaged, as this would go against the statutory scheme and would undermine the different time limits which statute has specifically set out as applying. So it would compromise, if not remove, the immunity of operational development after 4 years. And finally, the court said that these principles which we've just discussed are not undermined by the fact that it might create useless buildings. This is inevitable under the different time limits and should then feed into a local authority's assessment of whether it's expedient to enforce against the material change of use. Now, this final point arose out of argument in the court, where essentially the court was asked to find that there was a policy reason in order to allow the broader application of Murfitt. So essentially in this case, in the case of Caldwell, building a dwelling house on land previously undeveloped will likely to result in a change of use of that land. So far, so obvious. But that doesn't mean that the functional time limit for enforcement against operational development becomes 10 years through the application of the Murfitt principle. And that's essentially because the material change of use of the land was a consequence of and caused by the construction of the dwelling house. So it was, in the words of Mrs. Justice Leven, fundamental to or causative of that change of use. Essentially, then, the judgment in Caldwell reaffirms the primacy of Section 171B of the 1990 Act, and those time limits remain and enforcement must take place within them.
Absolutely right. And you're quite right to emphasise the relevance of 173.4a, because that's the grounding, isn't it, really, of the Murfitt principle. That's where it all comes from, the ability for local authorities to require the restoration of land against which they're enforcing. That's where it stems from. But it can't override the fact that we do have differing time limits, or do for the time being anyway, have differing time limits. Moving on then, we've heard about some important developments and some important changes. We've heard, as a matter of theory, about what Caldwell has to say about the Murfitt principle. Let's try and distill that into some more practical, on-the-ground tips. What do local authorities in particular need to be thinking about when considering enforcement action?
I think the key takeaway from Caldwell is that the local authority's hand is now significantly weakened when considering possibilities for enforcement. The requirement to consider Murfitt in a more limited sense means that local authorities now need to be much more careful when seeking to include operational development or other works within the scope of enforcement against an unauthorised change of use. Such enforcement actions will only be permissible if a local authority can demonstrate those operational developments or works truly are ancillary to the use and it's not the other way around. So local authorities will have to be much more cautious and careful about ensuring they're satisfied and, importantly, can satisfactorily demonstrate that any works they require to be removed as part of the change of use fall within the scope of Caldwell, again, that they are ancillary. And finally, it's also become harder to issue one enforcement notice which tackles both operational development and material changes of use together, as you need to be explicit from the very beginning what it is you are enforcing against. And as we've already said, Daniel, this is a very important point, but one of a limited duration. The judgment in Caldwell will be relevant for the next 10 years, while the different time periods for enforcement run through. So after 10 years from the 25th of April 2024, we're unlikely to encounter any of these difficulties because the time limits will be the same for both types of enforcement action.
Thank you very much indeed. Now, of course, one of the key features that we like to maintain on this podcast is the giving of practical advice. Thinking about enforcement more generally and where we are in light of the LURA changes, where we are in light of Caldwell and all the other things we've discussed today, are you able to distill down some useful practical tips for the listeners?
Absolutely. One of the things that can be very useful in enforcement proceedings, which is often overlooked, is the planning contravention notice, which is often issued at the very start of proceedings, but it's often forgotten that it is signed by the statement of truth. So can be useful later in proceedings for establishing firm dates if, for example, there's a discussion about material change of use. So as a very practical example, if planning convention notice was issued against an unauthorised material change of use and a response was provided by the person being enforced against to say that no one was in fact occupying the dwelling in question, let's say, if at a later stage during an appeal they sought to argue that the dwelling was in fact occupied, the planning contravention notice response would be extremely useful in providing a rebuttal to that point. Another point that comes up quite often is the need for certainty in drafting enforcement notices. We would always recommend to local authorities that they should look at the specific provisions set out in Section 173 of the 1990 Act and ensure that they've complied with all of those requirements. Finally, then, it's always recommended to, once you've drafted the enforcement notice, to read it in isolation. Absolutely forget everything you know about the site and ask yourself, is the breach alleged clear? Are the reasons for the breach clear? Are the reasons for the steps that the notice requires clear? And is the remedy clear? And with reference to that final point, important not to suggest a remedy that requires authorisation from the local authority. That will not be upheld.
Thank you very much indeed. Some extremely useful practical tips. Thank you very much indeed for joining us.
Thank you.
Well, there we are. Some very useful practical tips from Anna there in an area that is always beset with difficulty. Coming up, we have a very exciting autumn of planning related matters. We should have a new NPPF relatively soon. No doubt watch this space for some more content.